As per law, no wife shall be entitled to receive any allowance for the maintenance. If she is living adultery, the trial court passed an order of the interim maintenance of 20,000 per month, which is too exorbitant, Your Honor. Therefore, kindly set aside this order.
The maintenance concern reduced to 20,000 to 10,000. The husband.
That's what I asked you. You wanted to get instructions.
That's for 10,000. For time being, we are ready for 10,000.
It can be.
Lordship, it is too exorbitant. Regarding the, she herself left out the matrimonial house without intimation to the husband and also without to the wife house, matrimonial house, and also she is residing separately, and also destroyed my life at this stage. After a lapse of 5 years, she has filed the maintenance petition before this honorable court, Your Honor. The honorable trial court below has erroneously passed the order without consider the contention taken by the respondent, Your Honor. Being agreed by the said order, I prefer the above petition before this honorable court on this various grounds, my lordship. Because she is not entitled for the any relief as per law, my lord, because under section 125 subclass 4 of CRPC, my lord. No wife is entitled for any relief.
Where is it decided that she has decided?
She is residing separately, my lord.
That
also she is doing the adulterous life with someone.
It has to be proved.
It is a matter of trial, my lord.
125 CRPC proceedings will not decide all this. Have you filed an MC?
Lordship, I am seeking the, not seeking any matter, filed any petition for divorce till today. Further, my lord, on the ground of this, only seeking the relief of a man, only money minded, Your Honor. Accordingly, if she is ready, I am accepting my family. Otherwise, she is not ready. She left out the house. It is okay, my lord. Until without any grounds, she is not entitled for any maintenance, my lord.
Yes.
Because of she is residing separately, my lord. She has already executed the indemnity bond, which I produced at page number 20, in page number 22.
What indemnity bond?
What happened, my lord? When the marriage is arranged by her parents, she is not interested to marry the petitioner, my lord. After she have some affair with someone person. After marriage, she left out the only residing limited period, my lord, in my house. Therefore, after marriage, she is not residing permanently after lifetime. So she is presently also residing in other persons. So how can I bear this maintenance to her, my lord? It is the purely matter of law, my lord. As for 125 subclass 4 is very clearly settled principles apply. These correctly says that, my lord. My lord, as per law, no wife shall be entitled to receive any allowance for the maintenance or interim maintenance and expenses of the proceedings, as the case may be from the husband under this section, if she is living adultery or if without any sufficient reason she refused to live with her husband. So, my lord, is very settled principles of.
What is your income?
I am being the agriculturist, my lord, and also I am doing coolie also. There is no sufficient, there is no regular income. The trial court passed an order of the interim maintenance of 20,000 per month, which is too exorbitant, Your Honor. Therefore, kindly set aside this order and also kindly remain back to the press consultation.
With respect to the adulterous is concerned.
No, not you. Don't go into all that.
Evidence
about the income.
Income of the already stated manner is a cab driver. Is the cab driver. Number 2, the agriculture properties are in the name of his father, and after his death, the properties are transferred into the name of his wife, his mother. And in all, 2 acres 32, I own 3 acres of land situated in around the Devanandi city. And apart from that, around the agricultural income is more than 24,000. I stated
24,000
per month. Only in respect of agriculture properties concerned and cab driver. They are seeking for only 20,000 to the wife and children, wife and one child. Now he is studying 4th standard.
Yes, please come. Agreed with the orders passed in number 2 in criminal miscellaneous number 888 of 2022. dated 2nd September 2023, whereby the court had granted 20,000 as maintenance to the wife and the child. The husband is before this court, and counsel appearing for the husband submits that the wife is not entitled for maintenance as she has deserted the husband and she is living in adultery. It is submitted that the husband is ready to take back his wife, take back his wife, and under 125(4), it's very clear that a wife who is living in adultery and desertion and who has deserted the husband is not entitled for any maintenance. It is submitted that he is doing agriculture and is not having sufficient income, and in spite of the same, the court had granted 20,000 as maintenance, and the same needs to be set aside. His contention is twofold. One is that the wife is not entitled for maintenance, and even if she is entitled, she is not entitled for an amount. The amount of 20,000 that is granted is exorbitant. Next, when counsel appearing to the respondent, wife submits that the husband is having the father of the husband is having agriculture properties. His income per month is 24,000. He is working as a cab driver and is earning enough income. It is submitted that the wife is earning how much?
Wife is not.
I am presently, no my lord, I am not a cab driver. I am
What?
before,
Contention. That is his contention.
Wife
That
is
I have
not-
to record.
Wife is not earning much, she is presently residing with her parents.
It is submitted that the wife has to take care of the child who is aged,
Now in 11 years.
who is aged 11 years, and it's the responsibility of the husband to take care of the wife and the child. In response to that, when counsel the petitioner submits that he is only an agriculturist and he is not in a position to pay an amount of 20,000. That is exorbitant. Having heard the counsel's name said, there is a material on record. The first submission of the counsel with regard to the fact that the wife is not entitled for maintenance as she has deserted the husband and she is living in adultery. Both these aspects cannot be considered by this court in an application that is filed seeking interim maintenance. Admittedly, no MC is filed by the parties and there is no pronouncement by any of the court that the wife is either living in adultery or she has deserted the husband. In these circumstances, the court can only look at whether what is entitlement of the wife and what should be the appropriate amount. There is no dispute about the fact that he is having landed properties. According to them, according to the husband, those properties are in the name of property belongs to the father. According to the respondent, the petitioner will succeed to the said properties. And according to the petitioner, is working as an agriculturist. This court has perused the order of the family court, wherein the court has observed that the husband has filed his affidavit of disclosure of assets and liabilities, that he resides in his native place working as a coolie. It is stated that his mother is his dependent, is incurring 4,000 to 5,000 per month. His monthly income is shown as 10,000 and is working as a private company and drawing month. And according to him, the wife is working in a private company and drawing monthly salary of 15,000, but has not mentioned the employer of the wife. Hence, the court had considered the judgment of the apex court in Rasheed versus Neha, and considering the status of the parties' income earning capacity of the husband, had directed the husband to pay 20,000 and one-time litigation expenses 10,000. According to the wife, she is unemployed, and according to the husband, she is working. Considering the fact that even if considering the fact that he is working as an agriculture coolie, and the fact that he is having several properties, his father is having the agriculture properties, which in the joint name, or which he will succeed to. Further, the wife is taking care of the child. The amount of 10,000 would be an appropriate amount, considering the facts and circumstances of the case. In that view of the matter, this court is setting aside the order dated so and so. This court is modifying the order dated so and reducing the maintenance amount from an amount of rupees 20,000 to 10,000 accordingly.